Here's the number first before anything else. Default on a federal student loan and your credit score can fall by up to 175 points in a single reporting cycle. Not over a year, not gradually. One cycle. That's the kind of drop that turns a yes from a mortgage lender into a form letter that starts with "We regret to inform you." And the part almost nobody knows? You don't actually get arrested. You don't go to jail. There is no student loan police. But there is something almost as invasive, a legal mechanism that lets the federal government take money directly out of your paycheck without ever taking you to court. No judge, no jury, no trial. Just a letter, 30 days, and then a bite out of every check you earn. Let that sit for a second. We'll come back to it. Welcome to Catastrophe Theory, where we figure out exactly how fast your life falls apart if you actually let the intrusive thoughts win. I'm CJ Theory, and today we're looking at what happens when you open that loan servicer app, stare at the Make a Payment button, and just don't press it. Not once, not this month, not next month, not ever again. What happens when you ghost your student loans completely? Before we go further, I want to say something plainly because this topic carries a lot of shame with it, and shame is not useful here. If you are watching this because you are behind on payments right now, because you've been avoiding your mail, because you flinch when your phone rings from a number you don't recognize, you are not stupid. And you are not alone. Roughly 1 in 8 adults with student debt has fallen behind at some point. This is not a fringe problem. It is a structural one, built into a system that lent trillions of dollars to 18-year-olds and then largely walked away from the conversation about what happens next. So we're not here to scare you into shutting the video off in a panic. We're here to walk through, calmly and precisely, what actually happens minute by minute and year by year when a student loan goes unpaid. Understanding the mechanism is the first step toward never being crushed by it. Let's step into the scenario. You are sitting at your kitchen table. It's the 3rd of the month. There's a manila envelope in front of you that you've been avoiding for 2 days. You already know what's inside because you recognize the return address, that specific shade of government issue gray-blue that every loan servicer seems to use, like they all went to the same printing company and picked sober from the color wheel. Your coffee's gone cold. The laptop screen in front of you is open to your bank account, and the number in the top corner is smaller than the number you owe this month. And it's smaller by a wide enough margin that you already know what you're about to do, or rather, what you're about to not do. You close the laptop. You don't open the envelope. You tell yourself it's temporary, just this month, just until the next paycheck, just until things settle down. Outside, a delivery truck idles at the curb, its hazards clicking in a slow, patient rhythm. And for a second, that clicking is the loudest thing in the room, louder than your own thoughts, louder than the low hum of the refrigerator behind you. You notice how ordinary everything looks. The chipped mug, the junk mail you haven't sorted, a grocery list half written in your own handwriting, and how strange it is that a decision this quiet, this undramatic, could be the one that actually matters. There's no siren, no flashing light, just a due date passing unremarked into yesterday. That's the moment. That's the fork in the road. Millions of people have stood at that exact fork, and most of them didn't realize they were standing at a fork at all. They thought they were just skipping one bill. They didn't know they were starting a clock. I've spent time deep in the mechanics of consumer debt, reading servicer contracts, sitting in on calls with borrowers, tracing exactly what happens to an account after payment number 1 gets missed. I am not a lawyer, and nothing in this video is legal or financial advice for your specific situation. Please treat it as an explanation of the system, not a substitute for a conversation with an accredited counselor or an attorney. But what I can offer you is the anatomy, the actual chronology, because almost everyone I've talked to who went through default told me the same thing. The scariest part wasn't the consequence itself, it was not knowing when it was coming. So, let's take that uncertainty away. Here's a question to sit with as we go. If the system is this mechanical, this rule-based, this predictable, Why does it still feel like falling off a cliff instead of walking down a set of stairs? Keep that in your back pocket. We're going to answer it. Let's break down the anatomy of what happens when a loan goes unpaid, because federal and private loans are two completely different animals, running on two completely different clocks, with two completely different sets of consequences. Conflating them is one of the most common and most costly mistakes borrowers make. Part 1. The first 24 hours. The instant your due date passes without a payment, your federal loan becomes what's called delinquent, not defaulted, delinquent. Think of delinquency as the loan's immune system noticing a splinter. It's not a crisis yet, but the interest doesn't pause for you to catch your breath. It keeps accruing, silently, the way rust keeps forming on a car left out in the rain, whether or not you're watching it happen. For private loans, this same delinquency clock starts ticking too, but private lenders tend to move faster and less gently. Some begin reporting a missed payment to credit bureaus in as little as 30 days, which is 60 days ahead of where the federal system even starts to think about reporting you. So, if delinquency starts on day 1 and default doesn't happen for months, what exactly is happening in between? That gap is where most borrowers live, and it's the most misunderstood stretch of the entire process. Part 2. The 90-day mark. This is where the anatomy starts to show real teeth. At 90 days of non-payment on a federal loan, your servicer reports the delinquency to all 3 major credit bureaus, Equifax, Experian, and TransUnion. This is the moment the damage becomes visible outside your own bank statements. Up until now, this has been a private struggle between you and a loan servicer. At 90 days, it becomes public information, in the sense that anyone who pulls your credit report, a landlord, a lender, in some states an employer, can see it. Think of your credit score as a kind of reputation passport that other institutions check before deciding whether to trust you with something. An apartment, a car, a credit card, sometimes even a job. A 90-day late mark on that passport is a stamp that says in institutional language, this person hit a wall. It doesn't say why. It doesn't say you were laid off or that a parent got sick or that your hours got cut. It just says wall. For private loans, 90 days in, you're usually not just looking at a credit ding anymore. You may already be in the hands of a recovery department or an outside collection agency, because most private lenders default a loan much sooner, often somewhere between 120 and 180 days, and the credit reporting clock on those loans typically starts around day 30. This is worth repeating because it surprises almost everyone. Private loans can hurt your credit faster than federal ones, even though federal default carries scarier long-term tools. Part 3. 270 days, the line into default. 270 days is the number that matters most in this entire video. That's 9 months. 270 days of non-payment on a federal student loan is the official legal threshold where a delinquent loan becomes a defaulted loan. This is not a metaphorical line. It is a specific codified moment where the loan's entire legal status changes, like water crossing from liquid to ice at exactly 0 degrees. Before 270 days, you have options that simply vanish once you cross it: deferment, forbearance, income-driven repayment plans, in-network flexibility with your servicer. After 270 days, the loan can be transferred to the Department of Education's default management system and sometimes to an outside collection agency, and an entirely different toolkit of consequences becomes available to your creditor. Here's the part that tends to genuinely shock people. Once you're in default, the situation doesn't just get worse in vague, abstract ways. It gets worse in extremely specific, mechanical ways, because the federal government has legal powers that most creditors on Earth simply do not have. Part 4. The toolkit of default. The first tool is wage garnishment, but not the kind that requires a lawsuit. For most creditors in this country, if they want to take money from your paycheck, they have to sue you, win in court, and get a judge to sign off on a garnishment order. The federal government, when it comes to federal student loans, can skip that entire process through something called administrative wage garnishment. They can take up to 15% of your disposable pay, meaning what's left after mandatory deductions, without ever setting foot in a courtroom. You are entitled to 30 days' notice and the right to request a hearing to contest it, which matters, and we'll come back to that in the checklist. But structurally, this is one of the only situations in American consumer finance where a creditor can reach directly into your paycheck without a judge's signature. That's the mechanism I mentioned at the very top of this video. The second tool is the Treasury Offset Program, sometimes just called tax refund garnishment. If you're expecting a refund from the IRS, the government can intercept it and apply it directly to your defaulted loan balance before it ever reaches your bank account. If you're married and file jointly, your spouse isn't automatically protected. They may need to file what's called an injured spouse claim to shield their portion of a joint refund from being swept up in your default. The third tool, and the one that surprises people the most, is a Social Security offset. Yes, retirement and disability benefits can be garnished to collect on the defaulted federal student loan. There is a protection here. The first $750 a month is generally shielded from this offset, but anything above that threshold is fair game. Picture an older borrower who co-signed a loan decades ago for a child's education, now living on a fixed income, watching a portion of their monthly Social Security check disappear into a debt from another era of their life. This is precisely why this tool falls hardest on older Americans, and it's one of the least talked about consequences of student loan default in the entire system. The fourth tool, and the one that's subtler but in some ways more corrosive over the long run, is the loss of access to the federal aid system itself. Once you're in default, you generally can't receive additional federal student aid, which means going back to school, finishing a degree, or pursuing a certification through federal funding becomes far more difficult, an especially painful irony, given that unfinished degrees are one of the strongest predictors of default in the first place. You also lose access to every federal safety valve protection at once: deferment, forbearance, income-driven repayment. The exact tools that could have prevented default become unavailable the moment you actually need them most, like a fire extinguisher that locks itself the instant a fire starts. And then there's the diffuse, harder-to-quantify damage, the credit report acting almost like a second skeleton underneath your financial life, invisible until something needs to lean on it. A landlord pulling your credit before approving an apartment, a cell phone provider deciding whether you need a deposit, an auto lender deciding your interest rate. Even some employers, in certain states and for certain roles, particularly ones involving financial responsibility, are legally permitted to review credit history as part of a background check. None of these institutions see the story behind the number, the layoff, the medical bill, the year everything happened at once. They see a mark, and the mark does the talking. Microhook. And yet, as of right now, in 2026, several of these enforcement tools are actually sitting dormant. Why would the government build this entire enforcement machine and then simply turn it off? Stick with me. As of January of 2026, the Department of Education paused all three of these involuntary collection tools: wage garnishment, tax refund seizure, and Social Security offset, while it overhauls the repayment system to roll out a new federal repayment structure created under recent legislation. As of the time this script was written, that pause is still in effect, and no firm restart date has been announced. This is important, and I want to be extremely precise about what it means and what it doesn't mean. The pause does not erase your default. It does not reset your credit damage. It does not stop interest from accruing. It simply means the enforcement tools, the garnishment, the offset, are temporarily not being used while the system reorganizes itself. Think of it like a security checkpoint that's been told to stand down for renovations. The checkpoint still exists. The guards can come back on shift at any time. Building your financial plans around a pause that could end without much warning is, to put it gently, a fragile strategy. There's a second layer to this moment in history worth understanding because the ground itself is shifting, not just the enforcement schedule sitting on top of it. Legislation passed under what's been called the One Big Beautiful Bill Act is reshaping the federal loan system from the inside. A new repayment assistance plan is being built to eventually replace some of the older income-driven repayment structures. Certain existing income-based plans are being phased toward elimination, and starting in the middle of 2026, new limits are landing on deferment and forbearance eligibility, alongside new caps on Parent Plus borrowing and the end of Grad Plus loans altogether for new borrowers. None of that changes the fundamental anatomy we just walked through: delinquency, the 90-day mark, the 270-day long default line. But it does mean some of the softer landing pads that used to exist for struggling borrowers are getting narrower right as the system prepares to resume enforcement. In practical terms, the runway for getting ahead of a problem rather than reacting to one may be shorter going forward than it was 5 years ago, not longer. Part 5. The Lawsuit and the Judgment. Private student loans and beyond. Private student loans work under a different legal framework entirely, closer to how credit card debt or a personal loan gets enforced. A private lender generally cannot garnish your wages or freeze your bank account just because you defaulted. They have to sue you first, in civil court, and win a judgment. Only after that judgment exists can they pursue garnishment, and in the private world, the typical garnishment ceiling is higher, often up to 25% of disposable income compared to the federal 15%. If a private lender sues and wins, and you don't respond to that lawsuit at all, courts can and often do issue what's called a default judgment, a ruling made because you never showed up to contest it. This is different from loan default. It's a legal proceeding default, and it can lead to bank account levies, liens on property, and years of judgment enforcement action, all because a court date got missed the same way a payment did. And to directly answer the fear that shows up in the search bar more than almost any other, can you be arrested for not paying a student loan? No. Owing money is not a crime in the United States, and there is no such thing as debtor's prison for federal or private student loans. The only scenario where a court appearance becomes a legal, criminal-adjacent issue is if you are formally summoned to court over a lawsuit, for something like a garnishment hearing or to respond to a judgment, and you ignore that summons entirely. In rare cases, ignoring a direct court order, not the debt itself, can trigger a contempt proceeding. The debt is a financial problem. Ignoring a judge is a legal problem. Those are two very different categories, and conflating them is one of the most common sources of unnecessary panic in this entire topic. Part 5. The Exit Ramps. Default is not a permanent, unchangeable state. There are structured ways out, and it's worth understanding the architecture of each before you're standing in the middle of a crisis trying to figure it out for the first time. The first path is called rehabilitation. You agree to make 9 voluntary on-time monthly payments within a 10-month window, and the payment amount is calculated based on your discretionary income, sometimes as low as $5 a month for borrowers with very little income to spare. Complete those 9 payments and something remarkable happens. The default notation is actually removed from your credit report, not just marked as resolved, removed. This is currently the only path that erases that mark entirely. But there's a catch worth knowing up front. You can generally only use rehabilitation once per loan. If you default again after using it, that door typically doesn't reopen the same way. The second path is consolidation, rolling your defaulted loans into a new direct consolidation loan. This tends to move faster than rehabilitation, often taking a matter of weeks rather than the better part of a year, and it gives you immediate access back into income-driven repayment plans. The trade-off is that the default notation stays on your credit report even after consolidation clears the default status itself. You get out of default faster, but the scar stays a little longer. The third path, used far less often for federal loans but always worth investigating for private ones, is negotiated settlement. working with a default resolution team to pay a reduced lump sum that the lender agrees to accept as satisfying the debt. And the fourth path, obviously, is paying the balance off in full, though for most people standing in default, that's simply not where they are financially, and that's precisely why the other three paths exist. It's worth pausing on why these exit ramps exist at all, because it says something about how the system actually views default, at least on paper. A purely punitive system wouldn't bother building a 9-payment path back to a clean credit report. It would just let the mark sit there for the maximum allowable time and move on. The fact that rehabilitation exists, that consolidation exists, that there's a default resolution group whose entire job is negotiating settlements, these are structural admissions that default is expected to happen to a meaningful percentage of borrowers, and that the system needs a documented, repeatable way to bring people back from it, rather than treating every defaulted account as a permanent write-off. That doesn't make the process painless. 9 months of consistent payments while rebuilding your financial footing is genuinely hard, especially for someone who fell behind because money was already tight. But it does mean the path back isn't a secret, and it isn't a favor someone has to grant you. It's a published, standardized process that exists specifically because the system's designers knew from the outset that people would need it. Here's the cliffhanger heading into the next act. If all of these consequences and all of these exits are matters of public record, codified in law, documented, searchable, why do so many smart, careful people still believe things about student loan default that simply are not true? Let's take those myths apart one at a time. Myth number 1. Student loan debt eventually just disappears if you avoid it long enough. Reality: federal student loans do not have a standard statute of limitations the way many other consumer debts do. In most states, ordinary debts age out after a handful of years and become legally uncollectible through a lawsuit. Federal student loans are structurally different. The government's collection tools, including offset and garnishment, generally aren't bound by that same aging out clock, which means a defaulted federal loan can, in practice, follow a borrower for decades if it's never addressed. Private loans do have state statutes of limitations that can eventually bar a lawsuit, but, and this is the part people miss, the debt can often still exist on paper and still get pursued through non-lawsuit collection efforts even after a lender can no longer successfully sue you over it. This myth is false because it confuses "the lender might stop actively suing me" with "the debt is gone," and those are not the same thing. Myth number 2. Bankruptcy can't touch student loans, so there's no point even filing. Reality: this used to be almost entirely true in practice, even if not in the letter of the law, because the legal standard for discharging student loans in bankruptcy, proving what's called undue hardship, was interpreted so strictly by courts for decades that it was nearly impossible to meet. But this is exactly the kind of forgotten detail worth surfacing here. The standard hasn't vanished, and in more recent years, some courts and Department of Justice guidance have made that undue hardship pathway somewhat more navigable than it was in the 2000s and 2010s, particularly for borrowers with severe, long-term financial hardship. It's still a genuinely difficult legal process that usually requires an adversarial proceeding and, realistically, an attorney experienced in this narrow area. But nearly impossible and completely impossible are different words for a reason, and borrowers in true long-term hardship shouldn't assume the door is permanently welded shut without at least asking a bankruptcy attorney about their specific situation. Myth number 4. And this one might be the most emotionally loaded. Defaulting on my student loans means I'm irresponsible or a failure. Reality: default correlates far more strongly with structural financial precarity, job loss, medical emergencies, caregiving responsibilities, being steered into repayment plans that didn't match someone's actual income, than it does with carelessness. The system itself has, at various points, been criticized by its own internal watchdog for servicing failures, confusing paperwork, and borrowers being misdirected into forbearance instead of more appropriate income-driven plans, which quietly let interest balloon while the borrower thought they were doing the responsible thing by handling it. This isn't an excuse to disengage from the problem. The consequences are real, regardless of how someone ended up in default. But the moral framing of default as purely a personal failing ignores a huge amount of what actually drives it. This is why we opened this video the way we did. This is not a story about laziness. It's a story about a mechanical system meeting real human lives. And real human lives are messy in ways that repayment schedules are not built to accommodate. Myth number 5, and this one tends to trip up even people who consider themselves financially careful. As long as I'm making some kind of payment, my loan can't actually go into default. Reality, default isn't measured by effort, it's measured by the specific contractual payment obligation on your loan. If your required minimum isn't being met, even if you're sending something, even if you genuinely believe you're handling it, the account can still progress toward delinquency and eventually default. Because partial payments generally don't reset the clock the way a full on-time payment does. This is precisely why calling your servicer to formally restructure the payment, rather than quietly sending whatever you can afford and hoping it's enough, matters so much. An informal effort and a formally approved plan look completely different to the system, even when the dollar amount is identical. Let's move from myth-busting into something you can actually use. This is the part of the video worth saving, screenshotting, or writing down, because fear without a plan is just anxiety, and fear with a plan is preparation. Here is a checklist, 10 points for anyone standing anywhere on this timeline, whether you're 1 day late or well past the 270 mark. 1. Identify exactly what kind of loan you have before you do anything else. Federal and private loans operate on entirely different clocks with entirely different consequences, and the correct strategy for one can be close to useless for the other. Log into the Federal Student Aid website to see a full breakdown of every federal loan under your name, and separately check your credit report for any loans serviced by private banks or credit unions. 2. Call your servicer before day 90, not after. This sounds almost too simple to matter, but the entire architecture of federal student loans is built around proactive options, deferment, forbearance, income-driven repayment, that are dramatically easier to access before default than after. A 5-minute phone call at day 30 can prevent a 9-month rehabilitation at day 300. 3. Apply for an income-driven repayment plan if your federal loan payment doesn't match your actual take-home income. These plans recalculate your monthly payment based on what you earn, and in some cases that payment can be extremely low, sometimes near zero, without the loan going delinquent at all. This is often the single most underused tool in the entire system, mainly because borrowers don't realize it exists until they're already in trouble. It's worth checking annually too, not just once, because these plans typically require recertification of your income and family size, and a payment amount that was fair when you signed up can become badly mismatched a year or two later if your circumstances change and you forget to update it. 4. If you're already delinquent, request forbearance or deferment immediately, understanding the trade-off. These options pause your payments, but interest generally keeps accruing on unsubsidized loans, meaning your balance can grow while you're not paying. Use this as a temporary bridge, not a permanent solution. Think of it as a tourniquet, not a cure. 5. If you're already in default, request a copy of your loan file and confirm the exact amount owed, the servicer or collector currently handling the account, and whether it's still healthware or has been transferred elsewhere. Errors in loan tracking are more common than people expect, especially during servicer transfers, and you cannot negotiate accurately with numbers you haven't verified. 6. Choose between rehabilitation and consolidation deliberately, not by default. Pun somewhat intended. If your priority is fully repairing your credit report, rehabilitation is the only path that removes the default notation entirely, but it takes close to a year of consistent payments. If your priority is speed and getting back into an income-driven plan quickly, consolidation moves faster but leaves a visible scar on your report. There is no universally correct answer here. It depends on what you need most urgently. 7. If you receive any formal notice about wage garnishment, do not ignore it and specifically look for your right to request a hearing. You generally have 30 days to contest an administrative wage garnishment, and valid grounds include financial hardship, the debt already being paid, or the loan being tied to a bankruptcy discharge. This window closes. Once it closes, contesting becomes significantly harder. 8. If you're married and facing a tax refund offset and the loan in default is not your spouse's, file an injured spouse claim with the IRS to protect their portion of a joint refund. This is a specific form, not a phone call, and it needs to be filed correctly to be effective. 9. If a private lender sues you, show up. This is perhaps the single most consequential piece of advice in this entire checklist. A default judgment, meaning a judgment entered because you never appeared to contest the lawsuit, is dramatically worse for you than actually showing up and negotiating, even if you can't fully pay. Courts frequently offer more flexibility to people who engage with the process than to people who vanish from it entirely. 10. Seek a nonprofit student loan counselor before making any major decision, especially before paying a company that promises to settle or eliminate your student debt for an upfront fee. Legitimate federal loan rehabilitation and consolidation programs are free to apply for directly through the Department of Education. Any company charging you upfront to access those same free federal programs is, at minimum, worth being deeply skeptical of. A genuine advocate for you doesn't need to charge you a fee to hand you a form that's already free to fill out yourself. Read that list again sometime when you're not in crisis mode, because that's actually when it's most useful. The middle of an emergency is a terrible time to be reading anything closely. Print it, save it, send it to a friend who's been avoiding their own manila envelope. The value of a checklist like this isn't really in any single item on it. It's in the fact that it exists at all. Proof that this situation, as heavy as it feels, has a documented shape with documented exits that other people have walked through before you and come out the other side of. Notice what that checklist actually does. It doesn't promise the fear goes away. It doesn't promise the debt disappears. What it does is convert an overwhelming formless dread into a series of specific sequential actions, because that is structurally the entire difference between a catastrophe and a manageable problem. A catastrophe is something happening to you. A checklist is something you're doing about it. Let's slow down here because this last part isn't about mechanics anymore. It's about the emotional architecture underneath all of this. There's something almost engineering-like about the way student loan default is built. Deadlines, thresholds, tiered consequences, formal appeal windows. It has more in common with a pressure release valve system than with a moral judgment on your character. A valve doesn't hate the pipe it's attached to. It just responds mechanically to pressure crossing a threshold. 90 days is a threshold. 270 days is a threshold. 30 days to request a hearing is a threshold. None of these numbers were chosen because they know your name or your circumstances. They were chosen because systems need boundaries to function at scale across tens of millions of borrowers without a human being reading every individual story before deciding what happens next. That's not comforting exactly, but it is clarifying. The system is not cruel toward you personally. It is indifferent at scale to everyone, which is a very different thing. And indifferent systems, unlike cruel ones, can be understood, predicted, and, this is the important part, navigated. You cannot negotiate with cruelty in the way you can navigate a set of published rules. Rules have edges you can find.
Rules have appeal windows and payment plans and rehabilitation pathways written into them because someone, somewhere, anticipated that real humans would sometimes fall behind and built an exit ramp for exactly that reason. So here is the reframe I want to leave you with, because it's the whole point of this channel. We don't do this to make catastrophe feel smaller than it is. We do it to make catastrophe feel knowable, because the unknown version of a fear is always heavier than the mapped one. A stranger's footsteps behind you on an empty street are terrifying until you turn around and see it's just someone walking their dog. The fear doesn't come from the footsteps, it comes from not knowing what's making them. Student loan default has felt for a lot of people watching this like footsteps behind them for years. Vague, looming, undefined. What we just did was turn around and look at it directly. 90 days, 270 days, 15% of disposable pay, 9 payments in 10 months. These are not vague shapes in the dark anymore. They're numbers on a page, and numbers on a page can be planned around. I want to validate something before we close because it matters more than any statistic in this script. If you are in default right now, or delinquent, or just quietly terrified of the math not working out one of these months, that fear is a completely reasonable response to a genuinely difficult financial system, not a sign that you've failed at something everyone else finds easy. Millions of people are living inside some version of this exact scenario at this exact moment. You are not uniquely bad at adulthood. You are one person inside a very large, very imperfect machine, and the healthiest thing you can do is learn its rules well enough that it stops being able to surprise you. Think about how we treat other kinds of engineered systems designed to fail gracefully instead of catastrophically. A circuit breaker isn't a punishment, it's a safety feature, tripping on purpose so a small problem doesn't become a house fire. A car's crumple zone is designed to fold and absorb impact so the frame around the driver doesn't have to. Default, stripped of its shame and its stigma, functions in a strange way like that too, a formal, defined state the system falls into instead of simply collapsing into chaos when a borrower can't pay.
Nobody is arguing that, but it is a bounded one, with known thresholds, known exits, and known timelines, which is a very different thing from an unbounded, open-ended catastrophe with no way out. The difference between those two things, bounded versus unbounded, is often the entire difference between a crisis you can plan around and one that consumes you. Because here's the thing worth remembering the next time this fear creeps in at 2 in the morning while you're staring at the ceiling. Understanding a system doesn't just protect you from its worst outcomes. It gives you back the ordinary parts of your life that fear had quietly been eating into. The ability to open your mail without your stomach dropping, to check your bank account without bracing for bad news, to plan 5 years out instead of 5 days out. That's what preparation actually buys you, not the absence of risk, the return of your own attention, so you can spend it on your actual life instead of on rehearsing disasters that, with the right 5-minute phone call at the right moment, were often avoidable in the first place. Open the envelope, make the call, ask for the plan that matches your actual income. The clock is mechanical, which means it's beatable, but only if you're the one keeping time, instead of letting the silence do it for you. But that's just a theory. A catastrophe theory.